I'm attorney Dan Marr from the Nashua, New Hampshire law firm of Hamlin Kerrigan. I've been practicing here in New Hampshire for approximately 37 years, and in the Commonwealth of Massachusetts, I'm also licensed in practice for about 28 or 29 years. We're talking today about mature senior couples purchasing real estate together when they're unmarried, in New Hampshire particularly, and thoughts in regards to that when you're going forward with it. So I'm going to start off with the process of what a married couple or unmarried couple has when they own real estate together and what they don't have. So first, as a unmarried couple, if you both are owning the real estate together, then you have an interest in the real estate and you have to divide it if one of you want to leave. And if you can't agree to that, there's something called a partition statute, where you actually go into court and you let the court decide what interests you have in regards to that property. If one of you owns the property and the other one doesn't, the other one, under limited circumstances, can still make a claim to that real estate, saying that they did something that made them a constructive trust or a partner in that property. It's tough to deal with, though, because if you're in a situation where you move in with somebody and you're contributing to the expenses, usually the contributing to the expenses is going to be considered rent by a judge. So you're not going to have enough if you don't have an interest in the real estate. If you do have an interest in the real estate and you buy it together, often the closing company will just assume that you want it as joint tenants with rights to survivorship. In New Hampshire, joint tenants with rights to survivorship means that one of you dies, it goes to the other. Now, if you're an established couple and you've had a lifetime with other people before, maybe you're widowed or you're divorced and you have children from another marriage, you may have a concern about your interest in that real estate going to your significant other, because you want to provide also for your children. If you want to consider that, then you want to consider also what I'm going to be calling a cohabitation agreement, but also for the deed itself, you should probably put it into what's called tenants in common. And that the closing company knows exactly what I'm talking about. That means that your interest goes the way you want it in your estate, his interest goes the way he wants it in his estate. So that way you both are protecting each other's, your own families in regards to your interest in the real estate when you're holding the title together. That's a good idea. If you've actually gone into a situation where you've done a joint tenant with rights to survivorship and you thought that was a good idea at the time, and then the relationship is such that maybe you still are willing to cohabitate in separate bedrooms, perhaps, if your relationship has ended, but you don't want to sell the property quite yet, consider the possibility of you can actually break the joint tenancy. In New Hampshire, there's a couple of New Hampshire Supreme Court precedences on this, where one of you can deed it to perhaps your son, and then your son deeds it right back to you, and the purpose of that transaction is purely to break the joint tenants to rights survivorship and make it into tenants in common. Now, a lot of people would think, well, wait a minute, why doesn't that hurt the other person? And the Supreme Court has spoken in New Hampshire that you can unilaterally break that tenancy where upon death your interest is no longer going to the other person. Now, the other person is going to, of course, know about that. You should tell him or her about that situation. You should be upfront, but also anybody can go on to nhdeeds.com in the internet and search their records, and they can find out how the title of the property is. And it frankly does make sense once in a while for you, particularly if you're in a relationship, to double check to make sure that your significant other isn't putting liens on the property, doing loans or anything like that. You want to make sure and you can do that very easily by just going on to the registry of deeds electronically. So back to the issue of how you handle the property. Again, if you have other relationships, you should have tenants in common. Seriously consider, and I've done this for a variety of clients that are going into it, cohabitation agreements. Cohabitation agreements are such that you actually agree ahead of time what your percentages are, how those percentages can change over the relationship based upon contributions that you have into the real estate, but you're going in with your eyes wide open. You're a mature couple, you're an established couple, you've seen a lot of things. You're not just saying, well, it's all love and we're sharing all these things. You're practical. You still love this person likely, but you still are practical, and you want to make sure that your interests and those interests of your children are protected. You also want to make sure you understand what happens if one of you, and you can have this conversation, one of you needs assisted living. What's the circumstances on that? Is it you're not a married couple, so you don't have the same legal obligations that a married couple have as far as taking care of each other, but you still have an interest in this real estate and you want to have a conversation, a frank conversation as to how you want to deal with that. Do you have 50% interest in this? And then if you need to go into assisted living, the property is going to be sold so that you can get your cash out. So if you need it for to spend down before Medicaid, I don't know what your situation would be, but if that you want to talk through that circumstance with your attorney and figure out for estate planning how you handle that. So I've dealt with this in our firm. Our estate planning department has dealt with this for quite a while. I've dealt with the cohabitation agreements. They deal with the estate planning issues and making sure that you are protected that way. We're at 603-883-5501. Our firm is 603-883-5501. You can contact me directly at that number, and you can also check out my weekly vlogs. If you go onto our website, nashwallaw.com, that's Nashwallaw, one word, .com. Click onto my bio and look at the weekly vlogs of mine by topic, and you can decide which ones might be of interest to you, and you can listen to those anytime you want to. I'm happy to help you with the opportunity rises that get our estate planning department is excellent in making deal with your trust, your wills, powers of attorney, all the important issues that you should be considering for at any age, but certainly when you get more mature and you're thinking about all those considerations. 603-883-5501. Look forward to working with you. The opportunity rises. Thank you.